The Eastern Caribbean Supreme Court was established in 1967 with its headquarters housed in Grenada. In 1979, following the demise of Sir Eric Gairy's administration during the Grenada Revolution, the ECSC severed its relationship with Grenada and moved its headquarters to St. Lucia. Grenada was rehabilitated back into the ECSC some years later, but the court's headquarters remained in St. Lucia. The institution has made rapid strides over the past 4 decades, infusing creative, dynamic approaches to improve the justice system for the people of the region. As you will learn in this segment, the reform process is continuous, which bears testament that the Eastern Caribbean Supreme Court is an evolving court. Judges of the Eastern Caribbean Supreme Court serve the different member states and territories on a rotation basis. When assigned, they are required to relocate to the assigned island. Assignments are issued according to need and usually without any stipulated duration that he or she may stay in any one jurisdiction. As such, judges of the Eastern Caribbean Supreme Court may serve in several or all of the Eastern Caribbean islands in which the court has jurisdiction.
What is good about the Eastern Caribbean Court is that the jurisdiction is so wide that whereas in Guyana, you're sort of bridled to one jurisdiction. Here in the Eastern Caribbean, you have 9 jurisdictions to deal with, 9 different registrars, 9 different attorney generals. You know, it's a very wide experience for any judge.
We tend to move our judges around from time to time. Now, it would be appreciated that that is very disruptive. It's costly, not only for the court, but for the judges as well. And it affects the life of young children, having to move from school to school, from one group of friends to another, and so on. But it's also, in a sense, I think, an enriching aspect, because rather than being confined to one community, to one society, as in Barbados or Trinidad, our judges and their families get exposed to a variety of environments, both legal and social. And I personally think that that can be very enriching.
The rotation, yes, it must happen, but it should not be too frequent. And rotation should be done with adequate notice. I have known cases where judges have been shifted at a week's notice. Clearly, that is not fair. So that once we have a multi-territorial court, and where the basic principle is that you don't have judges remaining in their home territories, you're bound to have rotation, but it should be done with sensitivity.
The unique structure of the ECSC facilitates cost-saving benefits to the OECS member states and territories. The pooled judicial resources enable the individual islands to share rather than have separate and independent courts.
I think it would be more difficult for each island on its own to produce the resources needed to manage the court efficiently. And in any event, the issue of judicial independence, in my opinion, would have been far harder to maintain if you had a separate machinery in each island than to have one machinery representing the region as a whole.
The court's budget goes through an investigative process. It is prepared by the court's financial department. It is then scrutinized by the Conference of Ministries of Finance of the OECS. Thereafter, it is tabled before the heads of government, who are the approving authority for the budget. Once the budget is approved, a percentage of it is paid by each member state to the court. These percentages are dependent on the number of court sit-ins and resident judges that are assigned to the individual member states.
So some states pay 13%, some states pay 11%. I think there's one state that pays 8%.
Views on how the court is funded vary in the legal community. In fact, one view seems to suggest that this funding system undermines the independence of the court.
The court is a court that is delivering the quality of service that many members of the public are happy with, but the court cannot obtain the funds that are being budgeted for it because it lacks that financial independence.
We've got to educate our politicians that the court is necessary for a society to run on an even keel. And they must leave it to them, and they must give them their money. They must be funded. And it starts not only at the level of the judges, but at the level of the magistracy as well.
My concern is that there should be better security of tenure for our judicial officers, so that when they make decisions, it is based on the law and not whether they are fearful that some politician may be upset and then they will be transferred or something like that.
The time has come now when we say that the court must be given that true independence so that it can take the administration of justice to the level that it is already doing and remove this obstacle from the true independence of this court.
But one of the issues of impartiality has to do with the relationship between the executive and the judiciary.
I think our society is committed to the democratic principles, and a fundamental aspect of the democratic principles is the separation of powers and the independence of the judiciary. And our societies, our public at large, the legal profession and others have shown a commitment to do that.
We are accustomed to what we used to call the three streams of thing. You had the administrative, the executive, and the judiciary, and we used to say the three streams ran parallel but never mixed.
When I became a politician, I made it sure that we never tried to interfere with the work of the court. And I think that is very important that politicians don't interfere. And I don't, as far as I know, I remember, I don't think we have done any serious matter where the politicians interfered with the working of the court.
They have to learn that it has to be independent, but it's not a challenge to them. It's not a challenge to government. It is necessary that they should be independent. It is necessary, like an auditor should be independent.
Despite concerns for the court's funding system and the risks it poses to judicial independence, the Eastern Caribbean Supreme Court has shown over the years that it is an institution of impartiality and integrity. Evidence of this is reflected in the way the court has flexed its constitutional muscles in rulings which affect all citizens of society. Constitutional rulings include, but not limited to, the right to a fair trial, the right to freedom of expression, the right to freedom of association, freedom to practice one's religion, and other fundamental rights and freedoms existing under the constitutions of the various jurisdictions of the court.
We have set some landmark decisions in constitutional law which apply and guide courts not only in the OECS but in the wider Caribbean, and indeed I think in the Commonwealth and the world. We have established some very important initiatives. In particular, I always think of communications area, for instance with the Marpin case in Dominica, which opened up the telecommunications system throughout the Caribbean. It was a landmark path-setting decision. And then we had the John Benjamin case in Anguilla, which set new standards for public radio and public communication systems. Plus we've had a number of decisions in the areas of right not to be deprived of property without due compensation, and of course a number of cases in terms of the right to a fair trial within a reasonable time. So we've set a lot of landmarks and established some very sound jurisprudential precedents.
We've had several important constitutional cases, perhaps not as many as you'd find in some of the more developed countries, but we certainly have our landmark matters through detentions, through states of emergency, through other matters, land acquisition. All of these the court has been able to put its mark in terms of projecting itself and ensuring that the rule of law is prevailed.
The case of Hughes and Spence, those twin cases, which were on the same point of law, resulted in a change in the law with regard to the administration of the death penalty. You will recall that in those cases, the Court of Appeal decided that the mandatory sentence of death following a conviction for murder was unconstitutional. And that decision by the Court of Appeal was upheld on appeal by the Privy Council. So that since those decisions, a change in the law was brought about, in my view, unfortunately, not by the legislature, which I think in constitutional theory it ought to have been done by, in that such a fundamental change in the law, I think, ought to have been effected by legislative intervention and not by judicial innovation. But be that as it may, the Court of Appeal has changed the death penalty in the Caribbean and has said that whenever anybody is convicted of murder, it is up to the judge to decide whether or not the sentence of death should be passed, and if not, what other sentence should be passed. And that is clearly, to my mind, has been the most fundamental and far-reaching decision this Eastern Caribbean Court of Appeal has made in the time that I have been at the bar in St. Vincent and the Grenadines.
The integrity of a court of law is as good as its judges. Judges, therefore, have to not only be impartial, but also have the appearance of impartiality.
The judges have to free themselves of all kind of political thank yous.
In the Eastern Caribbean, judges serve jurisdictions with population sizes ranging from 4,000 to 200,000, relatively small compared to some CARICOM nations in the sub-region. The judge, therefore, is always conspicuous, and this adds more pressure to an already restrictive lifestyle.
You are assigned to a particular jurisdiction, a particular island, even though some judges have to move to more than one island in the course of their work. And because of that, you're under constant scrutiny. It means that whatever the judge does, he's known as the only or perhaps one of two or of three judges in the jurisdiction. And everyone knows who the judge is. Everybody knows what car he drives. Everybody pretty much knows what church he attends. And so like that, it's important, if you are to keep the profile of the judiciary intact, you have to ensure that you, like Caesar's wife, above reproach.
In spite of the close scrutiny of Eastern Caribbean Supreme Court judges, there have been no significant charges of judicial impropriety.
The integrity is as good as one could have hoped for, and I make bold to say second to none.
We've been fortunate to have people of outstanding character and probity in the Eastern Caribbean, and people of deep learning.
In a history of 40 years, going on 41 years now, to find that there have been only maybe one or two cases where questions have been raised about integrity of judges, and none of those issues has ever been resolved against the particular judicial officers. I think that's a proud record, and I think it's a record that we can be very proud of and that we must aim to sustain. The quality of our judges, the work they put in, I think there's a general perception that if a judge is not sitting on the bench, he's not working. So people say, oh, judges come to work at 9 o'clock and they go home at 1 o'clock, and you know, they're a lazy bunch of people who are just... But the reality is that judges work very long hours. They have to prepare the work before they sit on a case. They have to be familiar with the issues in the case and be able to grapple with the legal questions as well as the factual issues. Having heard the case, they then have to evaluate the evidence and also apply the law, the appropriate law, to the case. They then have to, in many cases, write judgments, or even if they give extempore judgments, they must be reasoned judgments which can stand up to analysis and can stand up to challenge before a higher level of court. And I think we can be very proud of the quality of the work our judges do.
Our judges, I don't know how they cope. They have to be going to court every day, and then they have to deliver judgment. When they go to the assizes, they have to prepare. You know, that's a tremendous amount of work. You have to burn the midnight oil.
We want swift justice, but we don't give the judges all the tools they need. They require. This is not 1910 or 1920. This is 2007. We're going to 2008. You can't expect a judge, and one of the judges here does all the aspects of the law.
A good practitioner would not want to go on the bench because of the salary. But the judges should be paid more because they work hard in it.
The general low levels of judicial salaries is very, very near to being scandalous.
The criminal assizes, the opening day, they have the parade. You dress like that for the thing. That was there all the time. In fact, criminal assizes, the judge, long time ago, had to wear scarlet robes at all times during the assizes. But when the change came around to dispose of the wig, and the complaint was heat in the Caribbean. Well, I didn't know that there was no heat before then, but suddenly heat became an issue or a reason why they said we should shed these ceremonial garments, wear them only on ceremonial occasions, but sit in court with just your black robes and no wig. I never agreed with that because I think it took away from the dignity of the court. You walk up there as a judge, you go on the bench, you have on your scarlet robes and your long wig to do the assizes. A prisoner comes before you and he's afraid to mess around with you.
As society changed and we approached the new 21st century era, the Eastern Caribbean Supreme Court looked at ways in which the court could adapt and better serve the people of the OECS region.
Everybody was complaining that it took too long from the time they filed the case to the time the case was heard. People were complaining about the cost of litigation, and they were dissatisfied to a large extent with the efficiency and the effectiveness of the judicial system.
We all know that justice delayed is justice denied. This is quite so.
With this as the underlying objective, the Eastern Caribbean Supreme Court embarked on a major reform process under the leadership of then Chief Justice Sir Dennis Byron. There was a perception that backlog plagued the ECSC, and moreover, Sir Dennis's convictions had to do with people feeling that the process of getting before the court is fair and even-handed to everyone.
Sir Dennis Byron will go down in history and has to go down in history as the reformer. Everything changed during his time.
The whole business of judging has become far more complex.
The reforms were wide-ranging and included 5 main components: development of a judicial administration structure which saw the expansion of the ECSC headquarters, the introduction of technology into the judicial process, an extensive overhaul of civil procedure rules, improving the standards of judges and all other officers that support the judicial functions, and court reporting, for which a school was established.
I think the court has responded very effectively to those changes.
In 1992, the ECSC appointed its first chief registrar in the person of now Madame Justice Indra Hariprasad Charles, who basically administered the court in those days.
Sir Vincent wanted the chief registrar to be in the office, so when I moved over from the High Court to the Eastern Caribbean Supreme Court,
and one became very familiar with the rules, and you became set in your ways, put it like that.
Since the introduction of technology into the judiciary, all judges were outfitted with laptop computers, and the entire judicial system is now supported by an information technology department housed in the ECSC headquarters in St. Lucia. The introduction of technology into the ECSC has facilitated another vital aspect of judicial reform. In 2000, the court adopted civil procedure rules, which have made a big difference in the ability of the court to administer civil justice in a timely, efficient, effective, and cost-saving manner.
we realized that it took too long for people to have their matters heard in the court, and also for judgments to be delivered.
With the new rules, the emphasis is on case management, and case management is supported by internal software known as Judicial Enforcement Management Software, or GEMS. This allows civil proceedings to be more court-driven as opposed to lawyer-driven.
And if it's there sitting for too long, the registrar now is able to do certain things by virtue of the rules, or the rules give time period within which, if I file a claim and it's served on the other side has a time period within which to respond. I'm not saying that the old rules did not have that time period, but now we have masters who sit and do case management conferences. So once a matter is filed, a claim is filed, there's a defense, there might be a reply to the defense and a counterclaim. It goes straight to case management.
The OECS, they deliver good quality justice. And they were able to do that because of the reform. In the old days, you had more or less trial by ambush, but you don't have that today. So when a litigant goes to do the preliminary matters like the trial review and case management, they're usually there, and they would know what is going on because they would be told you have to do this by a certain time and this has to be done and so on. So they would be prepared. And because of that, when you actually go into a trial today, they don't have all this big 16, 17, 10 days and so, because you just deal with the issues because all preliminary matters are dealt with before. So the litigant today would be able to appreciate what the issues are, and he would know beforehand what the cost situation would be, because that has a lot to do with it.
In many cases, when the parties put down what they were claiming, a lawyer, a qualified lawyer, reading the claim and the defense might be able at that stage to say, we don't need any further evidence to decide the case. So that's one. So the master had the power to enter judgment on the pleadings if what the parties said provided a sufficient basis for judgment to be made at that stage. Now, the rules also address this issue for how litigation fees should be calculated, but it also, in order to encourage early settlement of cases, it regulated that the percentages of fees which would be payable depending on the stage at which the matter was settled?
By and large, I would say that the CPR has been working. Seasoned practitioners at first were a bit diffident because we thought that it was a major change from the rules of the Supreme Court, which we were accustomed to. But they have been enforced now for the past 5 to 6 years, and I can say that it was a worthwhile change, especially for the administration of justice. I think that for the ordinary litigants, the persons who we are supposed to be serving, administration of justice is quicker. There's much more, for example, before we did not have mediation, we did not have case management, and from my experience, the case management has been working. I would say about 40 to 50% of the cases are settled at case management stage, and then those that go to mediation, I would say at over 50% are settled at mediation stage, which means that it reduces the backlog on the courts, and so justice is swifter.
And it depends on how the police investigate, depends on what success or failure we have in the High Court, together with the prosecutors.
I would expect that the court would be streamlined into divisions, criminal being one of them, that there will be a civil division. All these things are afoot.
One important thing that we must never overlook is the importance of all stakeholders in the administration of justice.
My information is that the University of West Indies received something like 1,200 applications for approximately 160 places at the Faculty of Law. So it gives you an idea of the demand for legal education in the region, which far outstrips the resources that the governments are capable of providing.